now. So again, good afternoon, everyone. It is my pleasure to welcome you after a longer break at our regular event called CrowdTuesday, where we offer participants insights in relevant crowdfunding related topics. My name is Ivona Skultetyova. I am a senior researcher and project manager at European Crowdfunding Network, and today I will be your host and moderator. It is good to mention that we are co-organizing this event together with the European Union Intellectual Property Office. We recently entered into cooperation agreements, so you will probably see more of these common activities coming up in this year and further, hopefully as well. If you are wondering what is EUIPO, EUIPO, or European Union Intellectual Property Office, is responsible for managing the EU trademark and registered community design. They also work with the IP offices of the EU member states and international partners to offer a similar registration experience for trademarks and designs across Europe and the world. As a part of their strategic plan, EUIPO has set up a dedicated SME program which aim is to empower EU SMEs to protect and enforce their competitive advantage in the form of intellectual property. So you see that focus on SMEs is something where our interests really overlap, and that's why we decided to cooperate closer than before. As you have probably derived from the title of the event and the little introductory speech that I have, today we will be talking about intellectual property and crowdfunding. Those are probably two topics that are not often discussed together, but we believe there is a lot of added value that can be derived from combining these topics, because obviously when a company is running a very public crowdfunding campaign, the proper arrangement of intellectual property, proper registration is very, very important to protect the competitive advantage of the innovative SMEs. And naturally, the innovative SMEs have to protect themselves from others infringing their rights or from them infringing rights of the others, as well as ensure that their intellectual property won't be replicated and thus is in order and is properly registered. So after this short intro, I would like to introduce our panel of distinguished speakers, namely Coro Gutiérrez, who is a seconded national expert currently working at the EUIPO customer service, will be our first speaker. Then Coenraad de Vries, managing partner at StartGreen Capital and co-founder of Oneplanetcrowd, a crowdfunding platform that focuses on financing sustainable innovation by new crowd finance instruments. And Coenraad is also a member of the board at ECN. And last but not the least, Sebastian Hanck, team lead in the department of EUIPO that deals with or that takes care of SME related initiatives. So our agenda will be as follows. Firstly, Coro will discuss basics of IP in a very illustrated and practice-oriented presentation. Then we will hear from Coenraad the platform's perspectives on IP in the context of crowdfunding campaigns. And last but not the least, Sebastian will present some unique opportunities and services that EUIPO offers or will soon offer to innovative SMEs. So after this short introduction and summary, I will give my words to Coro, who can start her presentation. The floor is yours, Coro.
Okay, thank you, Ivona, for your introduction, and good morning, everyone. For me, it's a pleasure to be here in the webinar, trying to contribute in the understanding of intellectual property. I would like to share my screen. Let me know when you see my presentation. Can you see it? Okay. Well, I know some of you are SMEs, some others are people from crowdfunding platforms, but it doesn't matter because for me the message is exactly the same for all of you. This message is that companies with intellectual property work better than companies without intellectual property. That means that intellectual property, in our opinion, in the opinion of the European Union Intellectual Property Office, add value to businesses. I can demonstrate it with some studies and statistics, but better than figures or numbers, I prefer go straight to the point and show you how does it work, how intellectual property help businesses. In this presentation, we will see first a short case study. I hope you will find it interesting and will help you to understand in an easy way the different IP rights. Second, we will analyze each IP right one by one with more detail, paying attention in the specific characteristic of each one. And at the end of the presentation, we will try to answer this question. Why does IP add value to businesses? Let's see the case study. This case study is based in a real one. You can imagine the example as a real SME that maybe, why not, is thinking in participate in a crowdfunding campaign. Anna is the owner of this veterinary clinic. You see Anna in the center, this blonde woman. And she loves animals and is always thinking about how to improve the life of pets and the owners. Many of her clients report the same problem with pets, is separation anxiety disorder. I don't know if you have the experience with your own pets, but separation anxiety consists in that when pets are alone at home, they start barking in the case of dogs and destroy all what they find. This is a horrible, I had this problem in my house. But then Anna, our pet, has been thinking in a device similar to a pet toy that can move randomly or remotely and then can mitigate the anxiety of dogs and cats. The idea of Anna came when she saw their own pets playing with the vacuum cleaner. This small vacuum cleaner, maybe you have one at home, the Roomba vacuum cleaner. The pets were playing with this vacuum cleaner and she had this idea. She was working on the idea and after making a computer control prototype, she decided to check at the clinic. The result was incredible. Dogs and cats were chasing the device, trying to hunt it down. And once hunted, the device dispensed a small spit of food, a treat. She decided to call it RoboPet as a brand and try to find financial support to commercialize it. What Anna was starting, and maybe she doesn't know, is an innovation process. Innovation can be defined as a process that goes from the conception of an idea to the launch of a product or a new process on the market. This process involves two phases. The first one is the research and development phase, and the second one is the commercial use phase. During all the innovation process, the legal protection of knowledge that at the end will be materialized in a product or a service will be essential. In this arrow that represents the innovation process, we can see all IP rights together. We have trade secrets that protect information that is valuable because it's secret. We have patents that protect technical inventions or procedures for the industry. We have copyrights that protect the creativity of human mind, including software. We have trademarks that protect the commercial identity of products and services. And we have designs. Designs protect the appearance, the external appearance of products. Patents, copyrights, and trade secrets play a very important role in the first phase of the innovation process, that is the research and development phase. And trademark and designs play a very important role in the second one, in the commercial use phase. Anna should know that her device involves all these 5 intellectual property rights, and she must be thinking in how to apply with these IP rights before going to the market or maybe to a crowdfunding campaign. She first will think in a trade secret for the original idea. When she starts thinking about how to deal with the dogs when they are alone at home, this first idea with the vacuum cleaner, she must protect it with a trade secret. Maybe using a confidentiality agreement with employees or something similar. She must think in how to protect the technical part of the device, the RoboPet, with a patent, of course. She must think in how to protect the software of the app with a copyright. And she must protect the RoboPet, the name and the logo with trademark, and the shape of the dispositive with a design. One of the biggest mistakes of Anna could be, for example, launch the product on social networks, publish an article or distribute a triptych with information about the new device, or making a public presentation without having protected the IP rights. This kind of presentation I know is usual in crowdfunding campaigns, but please never without IP rights. Without IP rights, you will be unprotected. Anna will be unprotected against imitators, and maybe for sure she will lose the competitive advantage. But before analyze the protection that provide the IP rights, let's see the IP portfolio, the second part of the presentation, and we'll analyze one by one each IP right in more detail. Well, if I ask you what is this product, maybe you say this is not the moment because we are not in a real situation, but people say it's soy or maybe coffee, but the fact is that we don't know what is this liquid. It's liaperrin sauce, but nobody knows the composition of these liaperrins. It's protected with a strong, very strong trade secret. This is our first IP right, trade secrets. Trade secrets, if we follow the directive of the European Union published in 2016, is any information which meets all the following requirements. Is not generally known, information not generally known, has a commercial value because it's secret, and has been subject to reasonable steps to keep it secret. Trade secrets can be any, I remark this word, any confidential information in the context of business that gives money to the owner. For example, can be a list of clients or a technical part of a dispositive, or maybe just a photography. Trade secrets have an unlimited duration if not discovered for another company, of course. And you don't register trade secrets in an IP office as we do with patents or trademarks. Companies must sign confidentiality agreements or non-disclosure agreements with employees and partners. But they don't guarantee exclusivity. What does it mean? It means that if someone discovers the secret, your trade secret, through reverse engineering or independently, what is absolutely legal, this company could even register your secret as a patent and prevent the original owner, you, from using it. Emblematic examples of trade secrets are the formula of Coca-Cola, all we know it, and the search algorithm of Google. But also small companies use trade secrets. This small company in Madrid is a restaurant, is famous in all Madrid for this spicy sauce for potatoes. They base all the business of this company is based in a trade secret, and they are working for more than 50 years. Let's go for the second IP right. Maybe you know this logo corresponds to the travel booking platform in Europe. In Europe, Omio is operating in more than 15 countries. But Omio is not just a booking platform. It's what we call a unicorn. It's a company, a startup, with a value over $1 billion in less than 5 years. As other young companies, Omio based the business of this company in an app. This app involves software, and software is protected with copyright. This is our second IP right. Copyright serves to protect literary, artistic, musical, scientific, and educational works, as well as computer programs or software. The right of the copyrights arise automatically with their creation. You don't need to go to an office and register your copyright, but it's recommended if you want to. You have to demonstrate in a public register. Copyright lasts for the life of the author and 70 years after the author's death. Let's see an example. Van Gogh, Starry Night. This is the painting, the famous painting. You can use it freely because the author died in 1890. Then since 1960, it can be used without paying royalties for everybody. All this product, you can sell it without paying royalties. But you cannot do exactly the same with the Simpsons. Because if you want to do it, you want to sell this kind of product, you have to pay royalties to the owner. The owner, I think, is the 20th Century Fox or maybe Disney, I'm not sure, but you have to pay the royalties to them. Let's go for the third IP right. If I ask you for what is this, everybody answer the same. This is Post-it, but it's not Post-it. It's a pack of Highland brand adhesive notes. For these notes, Highland is using an adhesive patented in 1972 by the company 3M for the famous adhesive notes. But patents expire after 20 years. For this reason, from 1992, any company can use this adhesive and commercialize this kind of notes with another brand, of course. That leads us to patents, the third IP right. Patents are titles that protect and give the exclusivity of use to the owners for technical inventions such as a new product, new machine, or a new industrial process. To be patentable, an invention must be new, involve in an inventive step, and have industrial applicability. Patents last, as I said before, 20 years without any possibility of renewal. This is a good example of a patent. It was famous in Spain. This company, Alta Eficacia Tecnológica, is a spin-off from the University Complutense in Madrid, and they patented a new contact lens with a filter to prevent the macular degeneration. Well, during 20 years, this company, Alta Eficacia Tecnológica, will be the only one that can produce and commercialize this contact lens. The fourth IP right. Now, yes, if I ask you what is this, everybody say Post-it. Of course, it's Post-it, and Post-it is a trademark. A trademark from 3M, the company. Trademarks are the symbols that customers use to choose a particular product or service in the market. They distinguish products and services from others or the similar characteristics. They have a limited duration if renewed every 10 years. Trademark must be non-descriptive and distinctive. What does it mean? It means that your trademark must not describe the goods or services you are offering, you are selling. These signs must be available for everybody to use. You cannot monopolize them. For example, Apple could be a very bad trademark for a company that sells fruits, a fruit shop or something similar. Apple is not possible to register as a trademark, but Apple is a good trademark for a company that sells computers, as we know. And in the same line, expressions as be happy or the best are clearly non-distinctive. And then it's better don't try to use it as trademarks. It's better to apply for a trademark with this kind of expressions. Let's go for the last IP right. What you see here is an image of a salt and pepper seller. It's a very famous design from a Mexican designer, has a lot of international prizes. And the way to protect this kind of designs is with an industrial design. Designs protect the appearance of products, the form, the shape, the color, without taking into account any of its functional or technical features. To be protected, designs must be new and possess individual character. The protection lasts for 25 years if renewed every 5 years. Well, this was the last IP right. Then we have arrived at the third part of the presentation, where we will answer this question: why does IP add value to businesses? Do you remember Anna, our vet owner? Yes, of course, you remember it. After this presentation, she were in the public, Anna should be aware of the importance of intellectual property rights for her business and thinking in how to protect them. Why Anna needs IP to add value to her business? The first reason is protection. If Anna decided to protect her device with an intellectual property right, like the patent, the copyright, or the trademark, she will be well protected. As an owner of an intellectual property right, her capacity to take legal action against imitator is highly improved. Second reason to protect the device of Anna with intellectual property is that as owner of IP rights, she will have exclusivity. That means a competitive advantage. For 20 years, the duration of the patent, the RoboPets can only be commercialized by the company of Anna. The third reason to protect her innovation with IP right is the possibility to use them to reach licensing or co-branding agreements, or maybe to sell directly the rights. Anna can sell the patent, the trademark, or whatever she wants. But license for me is one of the better ways to monetize the IP rights. They are contracts in which an IP right owner allows another company, a third party, to use in exchange for regular payments or royalties. And the other agreements, the co-branding agreement, is when two or more companies form an alliance to achieve common goals, creating a joint image that is stronger and have more action in the market. Of course, Anna, our friend, applied for the patent, the trademark for RoboPet, the design, and also protected the software of the app with copyright. Anna got the financial support and started to produce her RoboPets. Now she has signed a co-branding agreement with a very big vet center, and she's earning a lot of money. You can be Anna, for example, or you can be this other Anna without intellectual property. Can you imagine what would have happened if Anna had not protected her product before launching it on the market or before starting the crowdfunding campaign? For sure, she would be unprotected against imitators. She would lose the exclusivity and the competitive advantage, of course, and she would not have any licensing agreement or co-branding agreement with other companies. Our advice is please remember to protect your IP right before going to the market or to make a public disclosure of your innovations, because things happen. People are trying to copy you for sure. Well, I think I have my time end, and that's all from my side. I hope the value for businesses, or the value of intellectual property for businesses is more clear. And you, both companies and crowdfunders, are in a better position to start thinking in intellectual property. I think at the end of the session will be the opportunity for you to ask questions, or maybe you prefer to consult our information services in EUIPO. Thank you very much for your attention.
Thank you very much, Coro. Yes, you can stop sharing your presentation. Thank you very much for very brief, but in terms of information, very dense overview of this complicated topic for especially for SMEs, because it requires some understanding and knowledge that is usually developed over time. But it was the overview was very easy to understand. So thank you so much for that. And having said that, we can go to speaker number 2, Coenraad de Vries. And Coenraad, you are in this context representing the crowdfunding platforms that have to also deal with intellectual property when they are selecting companies that will run a crowdfunding campaign companies that will run a crowdfunding campaign on the platform. So what is your approach to intellectual property of these companies? How do you deal with it? How do you maybe examine it? And to what extent do you care about intellectual property when selecting proper candidates?
That's a lot of questions. I can only agree with Cora that the if you do a crowdfunding campaign, you go public, asking people to invest in your company. So by going public, you entering the phase where you have to make sure that you have registered your patents and your copyrights on the right way. Because it would be really disappointing if you raise money and then at the end of the campaign you lose your commercial benefit by having others copying your great ideas. So what we normally do is our platform Oneplanetcrowd, we do actually 3 forms of financing. We do energy projects, we do straight SME finance, which is a normal loan, and we do scale up companies. For instance, we have financed Van Moof. You might know them, the electric bicycle company, which is a really quick growing company in the Netherlands, but also Fairphone. You might also know them. They tried to change the cell phone market by having designed a sort of cell phone which can be reused. It's a completely circular cell phone because you can take out the blocks and then you can put in other blocks if you want to have an upgrade. And if you take those two, Van Moof and Fairphone, you have to see us as a sort of venture capitalist. So we check the patents. We check also in a quick scan the uniqueness of the patents, the commercial value on a quick scan. And we tell the crowd that there are patents, and we also tell them transparently which the patents are, and that the copyrights are correctly registered. But we don't go into really in-depth technical or commercial assessment, we go into that, but we don't present it on our platform to give the company a little less possibility to lose their commercial benefit. So the crowd also have to trust us on have taken these steps for a bit. So we sort of make a distinction between what we present and what we don't present. So we present that there are patents, we present that there's commercial value, that they are registered the right way, but we don't go into a sort of in-depth assessment on all these special elements to prevent that. Otherwise, you made it a little bit too easy to competition to follow the technical steps.
Mm-hmm. When the companies first apply to run a crowdfunding campaign at your platform, do they usually already have intellectual property in order, or is this some sort of new requirement that they didn't think about before they started fundraising? What is your personal experience?
They normally have, because we start doing crowdfunding if the company is in the scale-up phase. Mm-hmm. In the sense that they have technology and they are commercialize it and need money to quicker commercialize their technology. I think the phase before that you could also do crowdfunding, but it's much more difficult because then you have still developing your rough idea of your general idea. So normally we advise companies which are earlier than say the scale-up phase to use the other benefits of seed funds from the universities or subsidies or grants, which are there to develop your rough idea until something you can patent or something you can register as a design. Mm-hmm. So to your question, we only crowdfund if they're through this phase, so they already have registered their patents.
Mm-hmm. So they usually come to you in a state where they're already have some intellectual knowledge about intellectual property and how it is properly ordered. Yeah. Do they maybe sometimes complain about the costs of the putting your IP in order? Is it something that they feel significantly on their budgets?
Yeah, and sometimes you can also finance that by crowdfunding. I mean, it's not a problem to say, okay, I have to patent in these countries. I need more patents in other countries. That's something we can finance. But then you have to be then you have to be quick. But in general, the technical protection your first ideas in your first designs is expensive, and there's a high sense of entrepreneurial risk there, because you're not sure if your company will, if your idea will make it.
Absolutely. Yeah, that's true. Do you maybe have some anonymously or not anonymously a good or bad example from practice, that a practical case where it went really good or really badly? On the other hand, with the intellectual property and crowdfunding campaign.
Yeah, not on patents, but I had to think about the name. But I can remember that in the Netherlands there were 1 or 2 cases where people start to complain about the trademarks and the branding names in the middle of a campaign. So, for instance, if somebody was really successful on, I don't know, a healthy food company, then some other claimed in newspapers, yeah, we also called ourselves healthy and we're also doing food. So you are doing a crowdfunding campaign, but they are misusing our brand name. And it usually was not true, but it always gives a bad publicity around your campaign. In some sort of way, because I can remember a few cases where especially around the brand name, people try to cherry pick actually on a successful campaign. So if you have a successful crowdfunding campaign, then that you're in the papers, you're on social media, and then there's always a few smart, or no, they're smart, but at least they are some entrepreneurs want to misuse it by selling up. But that's also something I'm doing, and they're using my model or my brand name or so. Yeah, and then it's really important that we as a crowdfunding platform, because we are the sort of independent mediator, then it's really important we can send some sort of press release that, well, that's not true, because they have all the brand names registered and they have a unique model, so we don't know what this guy is doing, but they're actually not telling the truth.
Absolutely.
But I could not find in my memory some cases where actually patents were stolen or copied. But yeah.
Mm-hmm. I think in the context of, as you said, scale-ups that you have on your platform, usually that they usually have patents in order, but maybe trademarks are not the ones that people pay so much attention to, because they don't think that there is such a space for infringement. Whereas, as you said, even in these cases, trolls can occur and be more sensitive towards us.
Yeah, and trademarks are more easily to infringe, right? About trademarks you can have longer discussions about uniqueness, because a patent is really well written, and if it's a good patent, if it's good written, then it has this unique claims. But a trademark, yeah, you could even discuss if Apple is such they have the worldwide claim now, but it's still an apple, so so it's still also food. So in trademarks there's more discussion possibility, and so I think in general, if you're more vulnerable in your your branding and your trademarks than maybe in your patents, because your patents are probably, if you do it well, they have this unique claims.
Mm-hmm. Absolutely. Thank you so much, Coenraad, for your insights from the perspective of crowdfunding platform. I think if you have time, please stay with us and until the Q&A. Maybe our participants will still have some questions to you.
And maybe one small remark, if possible. So don't be afraid to go into a crowdfunding campaign if you have all your IP rights registered the right way, because it still is a great way to present your unique technology on a quick way to your consumers, which really can boost your growth. So sometimes we find entrepreneurs, we are really afraid, even if they have the trademarks and the copyrights and the patents, and they still are afraid to go public. And I don't think you should be afraid to go public if you have a good technology, because that's the only way to get easier customers, right? So crowdfunding can be a quick way to your customer, to find new customers and new money.
Absolutely. So it's good to be precautious, but maybe not too precautious.
Yeah.
And that's a nice segue to our third speaker and our third segment. because as I mentioned already during my conversation with Coenraad, it can be slightly more expensive to put your intellectual property in order. And that's also why some innovative SMEs postpone these issues to later stage. But there are opportunities and possibilities to find funding for registering your IP rights or for help with registering your IP rights. And some of those opportunities are also offered by our core organizers, EUIPO. So now I give my word to Sebastian Hanck, who will tell you more about the opportunities that EUIPO or EUIPO initiatives for SMEs in this respect. Sebastian, the word and floor is yours.
Thank you very much, Ivona, and thank you very much to Coenraad and Coro for your presentations, and also for all of you who are watching us now. So I'm here to present some of the initiatives launched by the EUIPO, but you will see that not only by the EUIPO, to make your life a little bit easier in relation to IP when you have to deal with IP issues. We know that there is a lot of information in what my colleague Coro and also what Coenraad mentioned before. So here the idea is not to give you a complete training on everything which can be done with IP, but just to make sure that you are aware of it and that you can access the information. No? And in addition, I'm going to tell you what we can do to support you and also to finance your request on IP in the European Union. So I have a few slides to help me doing that. So I will speak about a few topics. So I will speak about the SME Fund. It's a financial incentive available for SMEs, for European SMEs. Then I will present two services which are free also and which have been created to support you when you have questions or when you need advice in relation to IP protection. I will present you very quickly the website we have to gather all the information at the same place in order to make sure that you can find it if you need it. And I will tell you about a tool that we designed and launched recently for you, no, to apply for European trademarks. Let's proceed. So the first topic is the SME Fund. So the SME Fund is a financial incentive for European SMEs to apply for national, regional, or European trademarks or designs in Europe. No? So basically, you can apply for national trademarks or regional trademark or European trademark in the European Union and receive some refund. There is a process which I will explain now, but basically the message is that you can request either a refund on the applications that you do at national level or at regional level in case of Benelux, the BOIP, the Benelux office, or before the EUIPO for European trademarks or RCDs. Or you can also have another service, which here in the slide is called Service 1, but in fact is a service where SMEs, where you can request an audit. Basically, you have experts in IP that will look into your business, into what you do, how you do, and that will come with a set of recommendations that will guide you on how you can better use IP to make money, no, and to protect yourself. So for this last one, we offer a refund of 75% of the cost, and there is a maximum reimbursement of 1,500 euros this year for SMEs. So this is the financial incentive we have now for you. So basically, we don't do this alone, as I told you before. We do this in close collaboration with the Commission, the European Commission, and with all the European IP offices of the European Union. So this is a common effort, and we want to reach as many SMEs as possible in order to make sure that you use this money which is available for you. All SMEs of the European Union can apply, and we have a 20 million euros fund this year, 2021, for you to use, and it will work on a first come, first served basis. So this functions as a grant. It's a grant system. So basically, you have this infographic to illustrate a little bit the functioning now of the request. So basically, you go to our website and you will easily find the information on the SME fund. You apply. You request this financial support. So you will indicate that you are a European SME. You will give some data which we need from you, some tax identification number for us to make sure that that it's a real SME who is applying, and you will have to give us a bank account, an IBAN, in order for us to refund the money to you to your account. You request the service, then we will analyze your request. We will check if you comply with the conditions. So basically, if you are a European SME and that you gave the correct data to us, and then we will send you a grant decision. As from this point, you are invited to request the service you need. It can be the service I presented before, the IP pre-diagnostic, so the audit, no, the IP scan, also it can be called, where you have experts that will give you counseling, that will guide you and give you recommendations on what to do with IP, or you can apply directly for national, regional, or European trademarks or designs. So you would apply for the trademarks within 30 days from the date in which we have issued the decision, telling you that you can go ahead, that we will refund. And once you have done that, you have applied for your IP right, you will contact us back. We have another application form, electronic form online. Everything is done online, where you request a refund. And as from that date, we will refund you. We will send you the money back with a maximum of 1,500 euros within 30 days. Okay, it's a lot of information, but well, I will tell you where you can find it afterwards. Important to know that you cannot request the fund at any moment. We have opened a series of windows where you can apply for the fund. So basically, we have 5 windows opened this year. January and March are done. Now we had more than 3,000 requests from SMEs, and we have already distributed almost 2 million euros in requests. But the new one is opening this Saturday. So as from the 1st of May, all SMEs, European SMEs who need to apply either for IP rights in the EU or for an IP pre-diagnostic can do so as from the 1st of May. And the following one will be then in July. So this was for the first service, for the first one. So this is the financial incentive. Then we have 2 additional services which can be of your interest. The first one is what we call the IP pro bono, and the second one is called the effective dispute resolution. No? So what does this mean? So basically, you might have questions such as how to protect my ID, how to protect my design or the object I want to put in the market. Do you need to apply for a trademark? Will it be accepted? Is it okay? Do I have to do complicated searches before doing so? Or you have done so without advice, and now you have an opposition, or you have a third party contacting you, or you are already in conflict with them because they contacted you and they want to dispute. Or maybe you want to license and to make money with your trademark or your design. No, so basically, we offer this pro bono service, which is in fact a service where we put you in relation to law firms across the European Union who volunteer to offer this guidance, this free guidance, free of charge guidance. So what they did is that they enrolled to this exercise, and they offer a series of hours. So for example, you have a law firm in Brussels who offers 6-7 hours per SME, no? And they will receive your questions and they will guide you up to this time, no? And they will give you the guidance you need. The effective dispute resolution is a service where you are already in the process of a dispute, and where we will try to find alternative ways without entering into expensive and costly administrative burdensome processes, where we will try to reach settlements. Okay, so these are these 2 services which we offer you. Again, it works via a request on our website. I will tell you now where the information is. So basically, you go to our website, you identify the place where you can ask for this service, and you indicate the type of support you need, and we will guide you. We will tell you, okay, so in this case, it's more a pro bono, or it's more an effective dispute resolution service that you need. So within 10 days, what we will do is that we will send you a list of providers that meet your requirements, language requirements, of course, but also depending on the type of topic you need to be addressed. Then you will have 10 days to select one of the providers and to contact them and to start dealing with them, and hopefully you get the advice you need. Once the process is over, we'll contact you back to get some feedback and some info from you to continue improving the service we offer to the SMEs, no? Because we want to improve this. It's a lot of information, that's for sure. And as I said before, the purpose is not for you to take notes or to have all the information in your head, but to know that this is available for you. So this is a snapshot of our website. So if you go to the EUIPO website, you will easily find the SME Hub page, no? Or you will also see it as the SME Fund. We change the banner from time to time, but basically the information for SMEs is all at the same place. So please note that in this IDs, we call this IDs Power for Business Hub, you have everything that you need, all the information you need, and the application forms, no, to apply for all the services I just presented. You see that this is the way it looks. So you have in the middle the free personalized consultation. So this is what I mentioned, pro bono and effective dispute resolution. Then you have on the left side of the screen some very short videos explaining about trademarks and designs, just the basics, in case you are interested. And then on the right-hand side, you have the application forms in case you want to go ahead on your own, and the SME Fund information, of course. But this is very nice. But once you have decided to apply for a trademark, we understand that you are not IP experts. And applying for a trademark might seem to be something very complex. And in fact, it's not always easy, and you can do mistakes. But what we try to do, and we have been working hard to try to reach that point, is to offer you non-IP experts a tool which makes your life easier. So we have designed a new e-filing tool with some artificial intelligence, which is embedded there, with a friend, which is Camila, which is an avatar, who will be there to guide you while you do the application form. So this tool went live this year, a few months ago, and I must say that it will guide you through the process. So it will help you first identify potential trademarks which can be in conflict with yours. So we have an automatic search where you have a report that will indicate which trademarks are too similar or might be too similar to the application you want to make. It will help you to select the products or services that you want to link to your trademark, to the sign you want to protect. And it will be able to help you applying for a trademark in 3 steps, okay, in only 3 steps. So in fact, it can be a 3-4 minutes work, no? So we invite you to have a look at this. And the most important message, which I like to give when I end my presentations, in particular when it's so short because we don't have much time, is that we are at your service. And when I say we, it's not only EUIPO, it's all EUIP offices. So we work for you, and we invite you to contact us, not to hesitate to ask before applying, or if you need guidance. We prefer to have many questions before than to solve mistakes, which then can be expensive and can result in loss of money from your side. Okay, we have tools to reply to you. We have, you see here in the slide, the website of the office. We have an information mailbox for you. We have a chat which is available in all languages and which you can activate easily in our website. Don't hesitate to use it. And basically, this is what I wanted to tell you. I hope that you will make use of this information and do not hesitate to contact us. And this being said, now I give the floor back to Ivona.
Thank you very much. Thank you very much for also extremely interesting and I think beneficial overview that you provided. I think you can stop sharing your screen now. Perfect. All right, so we got to the last point of CrowdTuesday, and that's questions from our audience. So if there are any questions from the people present, please let us know. You can also activate your camera and ask them yourself, whether it is on IP rights or whether you want to discuss with Coenraad his approach or platform's approach to IP rights, or whether you are interested in the services that EUIPO offers to innovative SMEs.
Well, maybe I can break the ice. Thank you for the presentations. Thank you for the presentations. They were great, all of them. Sebastian, a little question. It is very useful and very interesting, the services that you mentioned, and they make a lot of sense to a lot of SMEs and startups. And as this service, there are many others offered by the European Union that are very relevant for everybody. But what we feel, or what I feel, is that it's difficult to know all of the services and benefits we can actually get, and it's not that difficult as we have seen. I mean, it's not a very complicated process, but it's just difficult to find the information. Do you know if there is a one-stop shop to try to find all of the possible services that one entrepreneur could find? Of course, there are several stages in a company, right? So either you're starting and you want to know, how to protect your idea, how to raise funds for the seed capital, how to, I don't know, maybe get support to build your business plan. Maybe there are services for that. How to get funded for any particular service. Is there a one-stop shop site for that where you can easily find that information?
Thank you very much for your question, Johan. And I invite my colleague Coro also to intervene, because I know that she knows a lot about that. What I would like to reply to you is that yes, well, no, the reply is no. We don't have this website available today, but we intend to go live very soon with the SME website, that we are preparing now with our partners, European offices, where we intend to have all this information at the same place. And yes, it's not only about IP; it's about many other topics which are relevant for startups and for growing SMEs. Coro, maybe you have more information you want to share at this stage with our colleague, Johan?
I have the same information as you, Seb, the same. We
Okay.
have to wait for the upcoming new website, no?
Yes, exactly. So now, Johan, this website is being built. So we are working on it now for a few months, and we hope to be able to be back sometime to present it, maybe, Ivona. And I tell you that in principle there will be nice features for you. Yeah.
That's great.
Yeah,
that's great.
But for sure will be very interesting, because it will include a visualization map, for example. Very interesting to find in each place, in each country of Europe, what you need. A part of training, tools very useful for in general for IP and more than IP. I think it would be great.
That's awesome, because there is actually some strategy in the EU. I mean clearly IP is one of them, right? We want to increase innovation and patenting in Europe, and we want to protect our ideas here. And so of course with this strategy you implement programs that make a lot of sense but that nobody knows, and so that's too bad, of course. Can I make just a comment / question to Coenraad? I am for the rest of the people that don't know me, I am CEO of a reward-based crowdfunding company in Portugal, and we also implement white label platforms. And one of the questions, of course, is how to protect my idea. And what we usually tell them, and what I think most investors tell you is, of course, you should not share the secret sauce for your product or business with the general public. I mean, you have to, of course, share what you need to share to make it sellable, to sell your product, to convince investors or to convince customers to buy your stuff. But sometimes even if you are protected, you can easily get copied. I mean, we had a lot of cases, especially in reward-based crowdfunding, where you're presenting a product and it's immediately copied by the Chinese, and then the product is available in Alibaba even before the campaign has ended. And so that's a real problem. And we've had several real cases, not in our platform in particular, but we've known of several cases in Europe. And even if you're protected, I mean, if you want to go legal with the Chinese counterpart there, it's going to take a lot of money, a lot of time, and it's probably not worth it. But I mean, is it also worth not going for it because you're afraid to be copied, or is it that there is room for everybody to try to innovate, even if you get copied a little bit, and that's part of the collateral damage, if you want? What do you think, Coenraad?
Yeah, I think for us, if a company only has one patent, we also, if it's really a tech company, we usually want to go for companies which have sort of a mother patent where they can develop all sort of devices on to have more flexibility. And in general, I think you should never be too afraid as an entrepreneur on people who copy you, because that's what always happens. But stepping into the arena without protecting yourself by the start is also not very smart. So I think you should do both. So you should try to protect yourself as much as possible, and then then have the collateral damage that people will try to copy you. But then at least then you're not, you're one step ahead in the battle. So yeah, I would advise to do both. So don't be afraid by not going. Try to raise money, try to make sure that people see you, and make a lot of noise so people know that you're the one who have invented it. But also on the backside, try to be, if possible, protect yourself with the registration and the patents and the brand mark registrations.
Great, thanks. And great to see you again, Coenraad. It's been a long time.
You forgot to mention you're also one of the board members, former board members. So.
Former board members, yes.
Yeah. Indeed. Are there any more questions for our panel of speakers?
If I can, Ivona, yes, I would like also to say something to Johan, because actually Johan mentioned a topic very important. No, it's a problem when you have to enforce your IP rights. So of course, for us, the situation. It's not easy to act when something is falsified or copied in outside of the European territory. However, and this would be a topic for another discussion. We have a tool which is available for IP rights owners. And when I say IP rights owners, it's not only trademarks and design, it's all of them, which is called the enforcement database. So basically, it's a tool which you can use, which is free of charge, which allows you to identify your IP rights. So it can be a design or whatever, and to inform the authorities, the national authorities, can be customs, police, etc., across the EU. All of them are collaborating with in this tool, using the tool, that there is some products which are coming within the European Union and which are copies of yours. Because when we speak with enforcement authorities, often the message we have is that, we see this object, it seems to be a copy, but we don't know who to contact. So this tool allows them to find very quickly who is the owner of the IP right and contact it and ask for what to do. No, so I just wanted to mention this very quickly, but we could expand on that.
Thanks. No, it's good to know.
Thank you very much, Sebastian. Indeed, I use these tools sometimes myself because I do get in touch with startup companies and innovative SMEs. So it is a very easy way how to find out if you potentially can infringe rights of somebody else. That's for sure. Having said that, I look at the time and we ran out of our time officially. So I would like to thank to our guest speakers. Thank you so much for your contribution, for all the information. We will post this this presentation and this webinar also on our YouTube. So you can how to look back at the presentations and contact our speakers in case you have any additional questions or in case you're interested in the services that EUIPO offers. So thank you so much on behalf of EUIPO and ECN, and we hope to see you soon at another Crowd Tuesday. Thank you and goodbye.
Thank you very much.
Thank
Bye-bye.
you very
Thank
much.
you all.
Bye-bye.
Pleasure.
Bye.